Attorney-General.
Okay. Call the Minister.
Mr Assistant Speaker, I rise to speak in support of the Terrorism High-Risk Offenders Bill 2017 and hopefully dispel some of the outrageous concerns that have just been raised by previous speakers from Newtown.
Order. The member for Newtown was heard in relative silence. So yes, she was. If the member from Newtown wishes to persist, I'll ask her to leave the chamber.
Thank you, Mr Assistant Speaker. With this bill, the government continues to ensure that New South Wales has not only the strongest counter-terror laws in Australia, something I certainly don't apologise for, but also the strongest laws anywhere in the world. Unfortunately, the Australian national terrorism threat level remains at probable. As recent as July, authorities detected a complex terrorist plot involving an aircraft, which is a stark reminder of the threat that exists. Thankfully, not all planned acts of terrorism are successful. Thanks to the tireless efforts of law enforcement and intelligence agencies, many terrorism plots at various stages of planning are detected and prevented before innocent lives are lost. There is no room for complacency. Mr Assistant Speaker, the bill will establish a supervision and detention scheme for eligible offenders who continue to pose an unacceptable risk of committing a future terrorism offence after the conclusion of a prison sentence. On application from the state, the Supreme Court will be able to make an extended supervision order or a continuing detention order. The maximum term of the ESO and the CDO is 3 years, although both orders can be remade by the Supreme Court at the end of the 3-year period if an offender continues to pose an unacceptable risk. An eligible offender is an individual who is 18 years or older and serving a sentence of imprisonment for a New South Wales indictable offence. This also includes a person who is continuing to be supervised or detained on a post-sentence order after serving a term of imprisonment for a New South Wales indictable offence. Before making an ESO or a CDO, the court must be satisfied that an eligible offender is one of the following: a convicted New South Wales terrorism offender which captures someone currently serving or has served a sentence of imprisonment for the New South Wales terrorism offence, membership of a terrorism organisation under Section 310J of the Crimes Act 1900, which is the New South Wales offence of membership of a terrorist organisation, or a convicted New South Wales underlying terrorism offender which captures someone serving a sentence of imprisonment for a New South Wales indictable offence that is connected to terrorism, or a convicted New South Wales terrorism activity offender which captures someone who is serving a sentence of imprisonment for a New South Wales indictable offence with no underlying link to terrorism, but who has become radicalised. Mr Assistant Speaker, this continued detention scheme is tough, but we make no apology for introducing laws that will keep the community safe. New South Wales has some of the toughest laws in Australia, and they are strengthened by these new measures to protect the community from known dangerous threats. This is about being responsive to the evolving threat of terrorism. If an offender possesses an unacceptable risk to the community, then it is critical that we address that risk proactively and without delay. And we could go through examples already that have occurred in recent years when this has been the case. The scheme builds on a range of reforms already introduced by the New South Wales Government, including new laws for investigative detention, a presumption against bail and a parole for anyone with links to terror, and providing certainly for police officers required to use lethal force against terrorists. Mr Assistant Speaker, this bill further introduces an important exemption for ASIO to the Privacy and Personal Information Protection Act. This acts on a recommendation made by the coroner following the tragic Link Cafe siege. This amendment will permit New South Wales public sector agencies to share personal information requested by ASIO that is reasonably necessary for ASIO to carry out its statutory functions. Exemption to privacy legislation is not something a government ever takes lightly, but with the appropriate safeguards, this provision will improve the ability of our intelligence agencies to keep us safe. The bill also makes important reforms regarding contraband offences within the New South Wales corrections system. It is entirely unacceptable that inmates and visitors risk the safety and good order of the correctional system by introducing contraband such as mobile phones, drugs or weapons. This reform will build on the good work of corrective services, which is most evident in the recent 11-week crackdown during Operation Purge. At each of the state's 36 correctional centres, more than 1,300 custodial officers and 90 Security Operations Group officers executed intelligence-based strays over and above each facility's regular contraband searches. The unprecedented operation produced great results, with searches of 8,377 inmates, 5,079 cells, 576 common areas, and I want to put on the record the government's appreciation to the staff across the correctional system for their hard work during Operation Purge. There is currently a gap in the local court's capacity to effectively punish longer-term inmates for possession of prison contraband offences, and currently the local court cannot impose any additional prison time on a contraband offender who is already serving a term of more than 5 years for other crimes. Instead, the time of imprisonment for the contraband offence must be served concurrently with the head sentence. The effect of this provision is that where an offender is serving a sentence in excess of 5 years, there is effectively no deterrent in relation to the prison contraband offence. Existing sanctions such as loss of privileges, restricted visits, deprivation of liberty and permanent changes of classification are used by corrective services in appropriate circumstances. However, there are a small proportion of offences which are serious enough to proceed to prosecution. Where this occurs, it is important for the local court to have effective sentencing options available. Readily available contraband in a correctional centre increases the potential for violence, bullying, standover tactics and conflict over debts. Furthermore, the availability of contraband contributes to the weakening of good governance and undermines the aim of a prison making a prison environment safe and secure. The bill will amend the Crime Sentencing Procedures Act 1999 to enable the local court to impose a new prison sentence on an inmate for a prescribed contraband offence, even if the new sentence would end more than 5 years after the existing sentence began. Prosecution for contraband offences in this context is appropriate, particularly given matters only proceed to prosecution when the existing sanctions do not reflect the seriousness of the offence, and the prescribed contraband offences are introducing or supplying drugs, alcohol or other prohibited substances in place of detention, introducing or supplying syringes into the places of detention, possessing offensive weapons in place of detention, using or possessing mobile phones, SIM cards or chargers in place of detention, and these offences are contained in the Crimes Administration of Sentences Act of 1999. Mr Assistant Speaker, the amendments relating to prison contraband offences will support the everyday good work of corrections officers in ensuring the safety and security of our state's prisons. Mr Assistant Speaker, I would like to echo the Attorney-General and thank all of those from the Department of Justice, Corrective Services, New South Wales Police and the Department of Premier and Cabinet who have worked hard to put this reform together. Mr Speaker, this comprehensive bill is yet another example of how the government's strong record of legislative reform improves community safety. The people of New South Wales can rest assured that the Liberal and Nationals government will leave no stone unturned in keeping our community free from terrorism, and I commend the bill to the House.
Questions.